Hi, I'm Harry Rock, and welcome to another edition of the Westfield Council on Aging Presents. This is a special collaborative effort between Tina Gorman, the Executive Director of the Westfield Council on Aging and the Westfield Senior Center, and Pete Coles, who is our producer here at WCPC Cable Channel 15. Our topic today is the path to same-sex marriage in Massachusetts. And I'm very, very excited today to have as our guest John Graney, who is the retired Associate Justice of the Massachusetts Supreme Judicial Court. We will be discussing the Goodridge versus Department of Public Health case and what it took for Massachusetts to legalize same-sex marriage as a landmark decision on November 18th, 2003. Massachusetts was the first state in the Union to legalize same-sex marriage. So, John, welcome to the show, and
Thank
really
you.
Thrilled to have you here.
Well, I'm happy to be here and to talk about the subject we're going to talk about.
You know, I always start with my guests just to allow our studio audience a chance to get to know who they're listening to a little bit. They know you by reputation. Certainly your name abounds everywhere in Westfield. You've had a lot of things named after you and the work that you've done. But did you grow up in Westfield? Or
Yes.
You're a native of Westfield?
Yeah, I'm a native of Westfield. I've lived here all my life except some time away for school and the military. I can give you a little bit my bio if you want.
So where'd you go to school?
Well, I went to St. Mary's for 12 years.
Oh, my goodness. That's
and
great.
Our family was of extremely modest means. So I really had no opportunity to go to college. However, I was fortunate enough to get a scholarship to Holy Cross, and that enabled me to go to Holy Cross. And then when I finished Holy Cross, I decided I wanted to go to law school. Also had no money, but I was fortunate to get a scholarship, full scholarship from New York University Law School.
Oh, wow.
So I went to New York University Law School, and while in law school, I worked for the local district court judge in the summer, and that put the notion into my head that after I became a lawyer, I really wanted to become a judge. And it moved on from there.
Wow. Now, growing up, had you thought about law and
No,
legal
no.
side of things as a business or as a career?
No, not in the slightest. We were basically worried about what we were going to do with our lives in general, whether we were going to go anywhere, and if we could afford college, would we be able to do it, or were we just going to have to go to work in, I don't know, the factories or someplace else. I mean, I started working when I was about 13 in the tobacco fields.
Oh, my goodness, really? Wow.
And it moved on from there. But things fell into place, so to speak, and maybe it was destiny, maybe it was hard work,
Right,
maybe it was a combination of the two.
right. Well, I would be remiss if I didn't do a quick shout out to your wonderful wife, Susan Graney, who I know will be watching this. We think the world of her as well. So let's jump right into it.
Okay.
This was a landmark decision, and I think I have it correct that Massachusetts was the
Yes.
first state to pass same-sex marriage.
We were, correct.
Which was, and I know, highly controversial and
At the time,
probably
yes.
still is today.
Yeah.
But when did the court start seeing the beginnings of gay marriage? When did that start coming really up on your radar screen?
Yeah, actually, it started about 10 years previously to the Goodridge case in 1993. Goodridge was 2003. We had a case called Adoption of Tammy, where two gay women in a same-sex committed relationship wanted to adopt a child. They were very prominent women. One thing as a strategy that the gay rights advocates do is they pick their plaintiffs who are going to file these lawsuits extremely carefully so that no one can really criticize or complain about them. Both women were doctors. The first woman, and she's identified in the decision, was Dr. Susan Love, who some people will recognize as one of the preeminent breast cancer specialists in the United States.
Oh, my goodness.
The second woman was a pediatrician, Both of them worked at the major hospitals in Boston, were on the faculty of the Harvard Medical School, and so on. The child, and Tammy's a fictitious name, that we use fictitious names in the cases for kids, was the biological child of one of them, who had been artificially inseminated by a cousin, who immediately signed off all rights to see the child. The child grew up really adoring the parents, called one Mom, the other one Mama. There were about 30 witnesses that supported the adoption, including their pastor at the local Catholic church and a number of others. So it really was an ideal relationship. The lower court judge allowed the adoption. No, it was a she, knowing that it would be appealed to us, and so it came. The question was, under the statute, could these two women adopt? The statute is very simple. It says a person who's of adult age may adopt any other person, with certain exceptions, who is younger. You can't adopt certain relatives and that kind of thing. So I was assigned to write the opinion, and I looked at the statute, and I said, well, adoption doesn't say anything about it can't be two women. In most cases, it's two people anyway, a man and a woman. In a lot of cases, it's a man by himself or a woman by herself. So on what we call a straightforward analysis of the statute, I said it could be done. At the time on the court, there were 7 of us. There are always 7 of us. 3 of the judges were Roman Catholics, and all 3 dissented and said this can't be done. But it was 4-3. So that started the path, in my opinion, towards same-sex marriage, which came 10 years later.
Wow. Were you surprised by the case seeking same-sex marriage? Or did you
no.
think that based on the tenor of the country, it was starting to move that way?
Well, yes, the tenor of the country. Gay rights were, had sort of been recognized much more significantly than they had way back.
But it was still early.
It was still relatively early, and there still was, and maybe still is, an awful lot of prejudice out there. But we watched the cases going through the lower courts, and of course we saw this case that had been filed by a group called GLAAD, which is Gay and Lesbian Advocates and Defenders. They are the legal arm of the gay movement in Massachusetts. And they decided, I don't know why, but that the time was appropriate to try and get a gay marriage. And since our court was considered a progressive court, not ultra-liberal, but progressive, that they would bring the case in our court. So they did, and we got it.
That's interesting. Was there other activity in the country going on that you were aware of? Were any other courts starting to think about this, or was Massachusetts really the forerunner to this?
Well, actually, the Canadian courts had already done it in a couple of the provinces, yes. And the European courts, some of them were beginning to consider it. I was unaware of any movement towards gay marriage as opposed to gay rights, which had been a movement for maybe 50 or more years. So I was a bit surprised that they decided to come to Massachusetts to give us the first opportunity to consider it. And so they did. And before we get to the case itself, let me tell you a little bit about how we prepare. We sit 5 days a month and hear maybe 25 appeals. About 2 weeks before we start sitting, the clerk will bring in these shelves consisting of briefs on the cases, and we try to read as many of them as possible. Well, one day the clerk came in with a full rack, like you'd see in the library where they stack books.
Oh, yeah.
Loaded with briefs. And I said to the clerk, what's that? And she said, that's the briefs just on gay marriage.
Oh, my goodness.
There must have been 60 of them. So I did my best, as did the other judges, to get up to speed, reading the two main briefs and some of the, what we call amicus, friends of the court briefs, before we heard the argument.
Wow, really interesting. You know, I was curious. I was just thinking about this. So, time-wise, and then we'll jump into the case itself. What was the period of time from the time that you first heard about it and realized that you're going to be dealing with it to when the final vote came?
Probably 6 to 8 months.
Okay.
We knew it had been filed in the trial court. The trial judge knew he had no authority to grant it, so he denied the request for gay marriage because he knew it was going to be appealed. I mean, he did the absolute right thing that he's supposed to do, and then it began wending its way up to us. Yeah.
Yeah, really interesting. So let's jump into the case itself and
Yeah.
kind of get a better insight of what that was.
Okay. Well, once again, the GLAAD, Gay and Lesbian Advocates and Defenders, had picked their plaintiffs very carefully. These were all people who had been in committed relationships for a long time, had adopted children, had some biological children through artificial insemination and so on, were engineers, accountants, business people, bankers, lawyers, physicians, so you couldn't say anything about their background. It was just sterling. So they brought the case, and GLAAD decided to focus on two main points, and we can talk about these. The first is that the existing marriage statutes do not have a rational basis, and that's a legal test, and I'll explain it. And the second one is under the Massachusetts Constitution, the denial of the right to same-sex marriage was a denial based on sex. And under Article 1 of the Massachusetts Constitution, there cannot be discrimination because of sex or race and a number of other things, but sex was the key word there. And keep in mind, as a result of not being allowed to be married, legally married, the plaintiffs and everyone else in their position lost a ton of benefits. If their partner got sick and was ill and was dying, they might not be able to see him or her in the hospital. Estate planning didn't result in tax savings that you get when you're married, and on and on and on. There were maybe 100 different laws, state and federal, but mainly state, they were interested in, that they were denied because of the fact that they could not get married. So we heard the case, and I don't know if you want me to jump into the two grounds I mentioned, but
Sure.
I can do that. Well, we have no idea before we hear the case, the justices, on what anyone else thinks. We make a practice of not going around and saying to someone, well, are you going to vote for this?
Okay.
Do you think gay marriage is all right? And the Supreme Court of the United States, I understand, does these things too. So it's just you and your two law clerks, and I used one law clerk on the case, who discuss it and decide what your position is going to be. So we heard the oral arguments presented by the attorney for GLAAD and the Attorney General, and then you go into what we call a samble, which is a meeting where all 7 judges gather. Everyone else is excluded from the room, and you discuss the cases. And that's for the first time when you hear how the judges think they're going to vote. And for me, it was the first time that I realized we were going to have a majority to approve gay marriage. Because as we went around the table, beginning with me as the senior judge, and then moving down in seniority, and then back to the Chief Justice as the last vote, it was 3-3 when it got to her. And she decided, of course, that she favored gay marriage, so it became 4-3. At that point, she assigns people to write the opinions, and we have certain major opinions. We call them Chief Justice opinions. So I said to her, this is a Chief Justice opinion because it's it's like the Bush-Gore elections.
Oh, yeah.
It's a big one. And she says, I'll write it. And she did. And she did a fine draft. But when I got the draft, and the other judges got the draft, I didn't discuss it with them, obviously. But when I looked at it, I said, I think there's a better way of doing this. So once you get the decisions, you meet again, and this is months later, to discuss the opinions. And it went around, and some 3 judges said they were going to dissent. The 3 other judges joined her, and I said, I'll join you as a 3rd judge to make 4, but I think there's a better way to do it, so I'm going to write what's known as a concurrence. Concurrence means I agree with everything you say, but I've got a new ground or basis on which I think it would be preferable. So it creates really 2 valid reasons for approving, in this case, gay marriage, and eventually Judge Ireland joined with me as well. So we had 4 judges in favor of her opinion, 2 judges with my opinion, and 3 judges based on solid grounds dissenting, and I'll explain those grounds if you want me to.
Yeah, I'd be interested in hearing that.
Well, first let's approach the grounds that the majority of 4 used. There's a rule of law that says a statute, in this case it's the marriage statutes, which are very peculiar, by the way. When I looked at them, I said, this doesn't look right. There are 2 marriage statutes. The first one says a man can marry as long as he doesn't marry his father, his grandfather, his son, and so on. It's all males. The second statute says a woman can marry as long as she doesn't marry her grandmother, her mother, her daughters, etc. And I said, well, this is odd. It doesn't talk about a man and a woman getting married, but that's the way
That's interesting.
That's the way it always occurred. But we didn't make much out of that in the opinion. But the first basis that the 4 of us joined, Judge Marshall discussed, was what we call the rational basis reasoning. A statute passed by the legislature deserves a lot of respect. And most times when they're challenged, we uphold them, obviously. But they've got to have motivating them, either express or implied, a rational basis, which means they make sense. And over time, that can change as society evolves. You could have a statute that said in the 1880s one thing, but if we looked at it now in the 2000s, we would say, well, this doesn't make any sense anymore. So the rational basis is not there. So what did the Attorney General argue were the rational basis supporting the statute so that we could, quote, uphold it and ban gay marriage? The first was tradition, that it's always been that way. Well, hell's bells with that. There are a lot of things that have always been that way. Slavery was that way for about 150 years.
Right, doesn't make it right just because it's a
and
tradition.
another 50 years after that, segregation of the races was okay, and then all those things got wiped off the books by the courts. So that was a fairly easy one to turn down. The second basis was that it's the ideal arrangement for raising children. And, well, it is and it isn't, because you don't have to be married to adopt a child. A lot of children are living with grandfathers and
Right.
grandmothers
Very
because the
different family
family's
model now.
gone south. and so on. So that made really no sense anymore. And the third basis was that it would, well, actually, there were four bases. The third basis was that it was the ideal situation for procreation. Well, that doesn't make any sense anymore because a lot of married people don't have children, and they're perfectly happy. And they don't go into the marriage saying, we're going to have 5 kids.
Right.
And single parents, the procreation isn't there and that kind of thing. So we discarded that one. And the final one, which was the weakest, is it preserves scarce state resources. And that made no sense at all because you were denying the gay people all these benefits under the statutes. But when you put the monetary value of what they were being denied, considering how small their population relatively is, it comes down to almost nothing in the state budget. And certainly they're entitled to Medicaid and free health care and all those kinds of things, and they would get that anyway. So we dispensed, or she dispensed, and I agreed with the rational basis arguments. But then getting to the second argument that was made, and it was not the principal argument, but they made it anyway because apparently GLAAD didn't think the court would adopt it, was that under the Equal Rights Amendment to the Massachusetts Constitution, this was an outright discrimination based on sex. So I focused on that in my concurrence, and I said it really is. You're denying A from marrying B because they're 2 men or 2 women, but you're granting A and B the right to marry if they're a man and a woman. So this doesn't make a bit of sense at all. And in Canada and the other places where they had equivalent equal protection, equality pieces in their constitution, they said the same thing. And one state had preceded us, and that was Vermont. And Vermont, the Supreme Court of Vermont, decided that 2 gay people could enter a marriage-type relationship, but they called it a civil union. I don't know if you remember civil unions.
Yes, I do. Yep.
And so the cities and towns, clerks and so forth, implemented civil unions. But in our case, when asked about this, the GLAAD lawyer said, and we agreed with them, the 4 of us agreed with them, this is a second-class status. I got a civil union, but you got the real marriage.
I got you.
And then you got to amend all the statutes to make sure you get all these benefits. So we said to Vermont, this is great. You sort of opened the door, but we are going to go all the way. And so we did. There was one judge who I was friendly with in Vermont because we get together for conferences and all that kind of thing. And she wrote a concurring opinion, too, saying in substance that civil unions didn't go far enough, but she couldn't get the votes to change the opinion. So we went up. We went the whole way, and that was that. We released it. I'll tell you about the day of release if you want.
Yes, I would be very interested in hearing that.
Yeah, on the day in November when it was released, a notice goes out at 9 a.m. in the morning on the internet saying the following cases are going to be released at 10 o'clock to the public. And up popped on this particular day Goodrich. Now, people were expecting it. They probably had known it was about due to come. So there's a huge plaza in front of our courthouse, and hundreds of demonstrators had gathered that day. And on one side were all those who opposed gay marriage with their signs and placards, and on the other side were all those who favored gay marriage with their signs and placards. And they were yelling at each other a little bit, but they were basically civil. So the case was released, and there was great disappointment on one side and elation on the other side. And I remember I needed toothpaste, so I went out the door and straight down the middle of this massive crowd yelling at each other, and nobody knew who I was.
Oh, my goodness.
And that's what happened
Oh, that is
that
funny.
day.
I was, I went online and I saw that just in the first 6 months, 6,100 marriages took
Yes.
place. And, actually 10,000 same-sex couples married in the first 4 years. So it was, and it wasn't until May 17th of 2004 when they started issuing
Yes, because
marriage certificates. So they
Yes.
couldn't get married right away. They had to wait
no,
until
they couldn't because
May 17th.
we postponed the effective date of the decision till the date you just mentioned, because we knew the city and town clerks and the Department of Public Health on the state level had to issue new guidelines. They had to change change their forms from man and woman, bride and groom to, 1 and 2 or whatever they decided to put down. So we gave them that time to do it. We also wanted to give the opponents, and I'll talk about this in a minute if you want me to, the opportunity to keep litigating the case, because they just weren't going to give up and say, oh, well, we're just delighted you did this. And they did. And I can talk about that if you want.
Yeah, it'd be very interesting because certainly you had the other side of the argument.
Yes. Well, there were three decisions that followed in that 6 or 7 month period. The first was the legislature, because they were really on the spot. And about, wow, what are we supposed to do? I think they should have just sat back and said, well, the court said so, and if they weren't happy, they would have, I'm not happy, but they did so. The court did so. But they didn't do that. They sent over a request for what's called an opinion of the justices. Now, that's peculiar to our Constitution. And the legislature and the governor, or either branch of the legislature, if they have an issue in front of them that involves the Massachusetts Constitution, or the federal, but the Massachusetts, they can ask us for an opinion on whether what they're going to enact is valid. And that makes great sense, because suppose, hypothetically, it was something to do with search and seizure, and they went ahead and enacted it. And then 2 or 3 years later, after maybe 1,000 criminal convictions under this statute, came to us and we said it's unconstitutional. Well, all those cases would have to be redone. So they sent over and they said, basically, we're willing to enact civil unions. Is that good enough? And we wrote an opinion and said no. Again, we split 4-3, and that was the first case. And by the way, the 3 who voted on that one and dissented from Goodridge didn't disagree necessarily with the result, but said the court shouldn't do this. It's too much of a social change. It should be examined and done by the elected legislature. And that's a permissible argument. We 4 thought the Constitution demands it and allows it, so we ought to do it. So that was the first one. Now, the opponents wanted to go ahead with an initiative petition. Under the Massachusetts Constitution, if you want to change if you want to amend the Constitution, you can get 10,000 or 10, I forget what the percentage of the voters are, to sign a petition to amend the Constitution, and then it goes to a general ballot in a statewide election. So they began that process to put whether the case could be overturned in an initiative, and it gets a little technical at this point. If the voters had overturned it, all the marriages that had occurred up till the point they overturned it would still be valid. You can't retroactively overturn it.
That's a good distinction.
But at least they wanted to overturn it. And a proponent of gay marriage sued, and said you cannot bring this initiative. And there's an arcane, and I won't get into it, distinction in the Massachusetts Constitution between what you can bring an initiative on and what you can bring a referendum on when you're dealing with a court decision. And we decided, looking at the language in those two provisions, that the initiative could be brought to eliminate or overrule, in effect, our decision. So we wrote an opinion saying that it could be done. And the third opinion, which I wrote again, was rather interesting. It went back to the legislature, and now they had to, on the initiative, they had to agree in a constitutional convention by a majority of the House and the Senate that it could go on the ballot. So they held a constitutional convention and on a bunch of other things. And right towards the end, with about 5 days left, and I think this might have been done intentionally, they got to the gay marriage thing. And it became apparent that they weren't going to vote on whether the initiative should go forward, because I think the reasoning was, well, if I vote to put it on the ballot, all the gay folks in my district won't vote for me.
Yeah, right.
And if I vote not to put it on the ballot, all the other people who oppose gay marriage won't vote for me, so I'm just going to sit here and not vote.
You're right.
So they filed suit to get them to vote, and it came up to us, and I really only had maybe a week or less to write the opinion, or maybe days. And I can't order the legislature to vote. I mean, what am I going to do? Put Don Helmison was in the Senate then.
Right.
Am I going to put him in jail if he won't vote?
Right.
So I wrote an opinion, and it was basically very critical of them in nice, polite lawyer language, excoriating them, saying they had taken an oath to vote on legislation and on initiatives and whatever. And this was controversial, but a lot of things are controversial, so you got to vote. So they did vote, and I watched the vote. It was on local television like you have here in Boston, because it was really heartrending, the speeches from them when they got up and defended or opposed and so on. And they couldn't get a majority to put the initiative on the ballot, and that was the end of that.
How much research, when you're writing these things, as you pointed out, you really don't have a lot of time to put this out, but
Yeah.
I'm guessing that you're really looking at a lot of research, or you're researching other statutes or other law cases, or is it really just looking at and thinking
Yes,
about it yourself and personalizing it?
Well, no, you just can't say, well, I'm for it. And
Right.
that's not the way the law works. You've got to have a solid legal underpinning to whatever decision you write, whether it's a murder case or a statutory construction case or two people fighting over
Right.
a contract or whatever. So it did require a lot of analysis and looking at what the terms equal protection meant, the prior cases that had dealt with statutes that were found to have a rational basis or not to have a rational basis. Whether you look at it through the lens of what's called originalism, which means what would they have done with this back in the 1700s when they wrote the Constitution,
Oh, interesting.
or whether you look at it through a modern lens, thinking that the Constitution evolves. So all of that goes into it. But frankly, there weren't that many precedents that had dealt with the subject before directly. There were a lot of precedents that dealt with equal protection and things like that. So by analogy, you sort of put together your opinion.
It was, as you pointed out, a 4-3 split.
Yes.
Really pretty much across the board
Yeah.
with all the discussion. Does that get contentious, or do they just have their point of view and you have your point of view? And
It's not contentious at all. It'd be like you and I disagreeing on whether the Yankees or the Red Sox are the better
Okay.
team, though I got the benefit of that argument this year at this point. It's all very polite. And like I said, their dissent, and each one of them wrote about it. is that it's not for us to do this major social change. It's for the legislature ultimately to do it. And frankly, I think if it was for the legislature to do it, it probably still wouldn't be done. But
Right.
so we started the ball rolling, and I can tell you what happened after that if you want, if you got time.
Yeah, I'd be very interested in hearing that.
Well, two points there. The first thing was, did we get a backlash personally? About a month went by, and I said, well, this is really surprising. I haven't heard from anybody that was really upset about this decision. And then one day, the public relations officer for the court walked in, and she said, I was saving these for each of you. And she had a file about 3 inches thick. And I said, well, what's that? She says, these are all the emails we received
Oh, my
about the
goodness.
decision.
Wow.
So I started going through them, and about half of them were, oh, this is wonderful, and thank you, and et cetera. We're liberated, and so on. And then a lot were, you're going to go to hell, and may you die of cancer early,
Oh,
and
my goodness.
from the South. A lot of these were from the Bible Belt.
Oh, so they came in from all over, not just from
all over,
Massachusetts.
all over the country, actually.
Oh, my
Yeah.
goodness.
So we had that. The second thing that was kind of humorous that happened to me, and also I think to Judge Ireland, but there was a publisher of a legal newspaper, quite successful newspaper, who was very much opposed to gay marriage. So he hired an airplane to fly over my house with a banner saying, impeach Judge Graney. And then this was during the Big E. He had it fly over the Big E because I saw people and they would say, oh, my God, we're at the Big E and there's this plane flying and it's got this banner behind you to impeach you. And I said, oh, well, yes, and that's going nowhere because the legislature didn't want any part of that. Frankly, I think in the last analysis they were happy that we did it, particularly with what has occurred now, because it took a lot of pressure and heat off of them. Then the question came up as, well, is this going to fly in the rest of the country?
Right.
And I said to myself, well, I doubt it. Maybe in New England, the New England states, because they're fairly progressive, in California and Colorado and a few states out west. But when you're talking Georgia and Mississippi and Iowa, it's not going to go anywhere. And the first thing that happened was the New England states, their courts all wrote opinions saying they were going to have gay marriage. And then all of a sudden, Iowa approved it by a vote of the judges by a vote of 7-0. And I said, well, this is pretty good because here's a fairly
Right.
Republican conservative state.
Sure.
And then about a year later, I ran into one of the judges at a judicial conference, and I said, well, that was really gutsy of you to do that because you're elected judges. And he said, oh, yes. And then he said in the process, we were on the ballot for re-election the next year, and all 7 of us lost.
Oh, my goodness.
And
Is
they
that
lost their
right?
jobs, which points out that I think, and people might disagree, but I think we're much better off with an appointed judiciary that can serve until age 70 than an elected judiciary.
You're
where-
not influenced by...
Yeah, when you're not influenced
Right.
by all of that.
Right.
So that happened. Finally, the United States Supreme Court, when about 30 or 40 of the states had approved gay marriage, they went ahead and did it in their case. And they adopted basically the reasoning we had used
Wow.
and the other courts had used
Wow.
because they copied us in writing their opinion. And that's not uncommon for them to do because the United States Supreme Court, when you've got a big issue like this involving states' rights, they will let it percolate until they see how the states are going.
Oh, okay.
And now the direction was clearly in favor of same-sex marriage.
Oh, that's
So they
interesting.
said, okay, maybe it's time now for us to take it up. And they did it. And they were a split decision, too, because the conservative Justice Scalia, Thomas, and so on were very much against it.
Right. Where did the state attorney general stand on this entire thing? And does his opinion weigh in on it at all? Or
That's an interesting subject. The state attorney general at the time was a Democrat, as I recall, and he, I think, highly favored it. And the woman who argued the case on behalf of the state, I was talking to her at a bar meeting about a year later, and I said, well, how did you end up arguing the case to turn down gay marriage? And she said nobody else in the office wanted to do it. We all favored gay marriage. And finally, she said, I realized somebody had to do it, so I went to the Attorney General and I said, I'll write the brief and the argument and try to vindicate the statute. And she did a fine job. Yeah.
that's interesting. Well, you must take some real pride in knowing that your work in particular and the work of your fellow justices really created this landmark decision that influenced the direction of the entire country.
Yeah.
And everyone was watching us, and
Yeah, you're doing your job, and fortunately, in the position I was in, I was given the opportunity to rule on something that was extremely significant. I ruled on a lot of other things that were extremely significant that I won't get into today, that received press and publicity and were controversial. But this was one that really, in my opinion, moved society forward considerably. And on June 2nd, I think, of this year, I was at the flag raising at
Yes.
City Hall,
right.
and it was just a delight to see all these people.
Yeah, the Gay Alliance flag
Gay,
raising.
the Pride Alliance.
Pride Alliance, right.
Yes, and to see them and to be allowed to help them raise the flag, and in particular to see the young people, college students, high school students, who were finally able to come out and say, here I am, I'm a person, and I can get married, and I can associate, and I have all the rights that all you other people have.
Right. Do you feel that, I see, controversial laws will get passed and then down the road, all the, momentum builds to rescind them into,
Too late.
this is too late, this will never,
It'll never happen.
oh, that's good to hear.
Yeah. They'd have to amend the Massachusetts Constitution, which you can't do. We've already said it can't be done. They'd have to amend the United States Constitution. Any presidential nominee that even suggested it would be defeated. So it's
So it's well locked in then.
Yeah,
that's
it's not an issue like abortion, which we're going to fight over
right.
apparently forever. But
I know. That's what I had in mind, quite frankly.
and I think a lot of people that initially opposed it now say, well, I don't know why we did that. These are wonderful folks. I work with them, and so on.
Right.
Yeah,
Right. That's amazing. You served 18 years?
on the SJC.
Yeah.
I was a judge for 35, and I served 20 on the SJC.
Wow.
Yeah. Then I taught in law school, Suffolk Law School, for 7 years. And then I joined the law firm in Springfield 5 years ago.
No stopping you.
Well, I don't know about that.
Well,
Time will eventually, but
yeah, well, you've had an amazing career, and I think you can look back. Hopefully, we all look back and say, "Okay, what was our contribution to society?" But
that's a good point.
you've had a tremendous contribution and influence and impact for men and women nationwide, and
Yeah.
yeah,
You don't realize it, sometimes I reflect. As you get older, you reflect. You probably are reflecting.
yep,
And you say to yourself, well, why was I put here?
Right.
And then it begins to fall into place, maybe to be a lawyer, maybe to
right,
be a judge, maybe to, handle important cases, and then maybe to do something like same-sex marriage or adoption of Tammy
Right.
or one of these other
right.
really big cases.
Well, I would say that you've done a great job with your life when you think about growing up in modest means, working in the tobacco fields,
Oh, a lot of us did.
finding your scholarships, getting your scholarships to go to college, and then making the most of it. So, I have to say on behalf of our community of Westfield,
Thanks.
our Commonwealth of Massachusetts, and our country, thank you to retired Associate Justice of the Massachusetts Supreme Judicial Court, John Graney. Thanks so much for being here today.
Okay,
We
thank
really
you.
appreciated hearing the story. Very interesting. A lot of us know of it, but we certainly didn't have the insight. And again, thank you for your leadership on that. So, on behalf of Pete Coles and Tina Gorman, I am Harry Rock. Thanks so much for tuning in. You have been watching another edition of the Westfield Council on Aging Presents. Thank you so much. Have a great day, everybody.